Okay, good morning, Your Honor. Sanford Rockowitz for DM, the mother. I would call the paramour, I guess I would call him paramour because I'm used to doing that. I think the focus in this case should really be more on how it developed that the mother lost custody early on.
Would you like to save some time for rebuttal?
Excuse me?
Would you like to save some time for rebuttal?
Yes.
2 minutes? 3 minutes? 2 minutes? Okay. Thank you.
All right. Well, essentially, she had a very troublesome relationship with the grandparents. And what was really interesting is in December, she took the child to Miami with the paramour. She took away from the grandparents. And from December until May, and then in May, the grandparents filed a petition to regain custody, alleging that the paramour had a violent history, that they visited him and he was very aggressive and he had marijuana in the home. That was basically what they were saying against him. In June of 2009, there were bruises of the child found at the daycare. But from January till that time in June, the child was at the daycare living with the mother and the paramour. And the daycare workers, employees, all testified that the child seemed to be loving towards both of those persons all that period of time. The bruises, according to Dr. Lambert from the Child Protection Team, he said they were not severe. And other than those bruises...
How old was the child?
At that time, I'm trying to remember. Not sure, 3 or 4. The child was able to speak.
He had bruises inflicted by
either one or both of
these persons, but they weren't severe, so it's okay?
No, it's not okay. But they weren't severe.
But it's abuse.
Yes, it is abuse. But the standard for this case is dangerousness. Would the child be endangered if returned to the mother's custody?
It is in danger of further abuse.
In danger of further abuse?
Yes.
I would say...
Imminent danger of further abuse.
Prospective further abuse?
Yes.
Right. Serious abuse. But the question was, how would they be able to place the child back with the mother where it would not be dangerous for that child to be in that situation?
Well, you testify, you argue about the spatula, but didn't the mother actually testify that, in fact, she was having the child hold up her bed?
She was having the child, I'm sorry?
Hold up her bed?
Yes, and I don't think that was true. I think according to Dr. Lambert, the child had been abused by the stepfather with a spatula. And ultimately the mother said, I agree. I agree that...
Well, Dr. Lambert said that one of the bruises could have been consistent with the child falling against the bedpost, I guess, in the jaw. And then the other 2 were linear in nature, and they more likely would have been caused by the spatula, correct?
Exactly. But he still characterized...
Doesn't that indicate that she's covering up for her boyfriend, whatever, paramour, and denying that these things existed, which shows that she doesn't care or is going to deny or is not going to protect her children from the further conduct of the same kind?
Well, I think in the beginning, I think she was in denial, and I think that she did resist having no contact with him. I think she went to therapy over and over again. A number of therapists said that she did not have a serious mental illness, that she did have some difficulty in denying what was happening with the paramour.
But she was ordered not to have contact with the paramour, correct?
Correct, and she violated that.
And
she admitted she did that. She admitted she did it. She talked about how she'd lost both of her children, that her parents and her were completely alienated from each other, and that she felt desperate financially as well. The reason she gave...
Why would they alienate? The reason for the alienation was because of the way she treated the children, or allowed the children to be treated by others.
Well,
it was over they were alienated over the welfare of the children.
That she was doing that for a long period of time. I agree, but ultimately she said, and she testified, that she would never allow further contact with the paramour and with her child. And
the trial judge, for some reason, I can't understand why, didn't believe her.
Well, didn't believe her. But what I'm trying to emphasize is that other than the bruises, all that time that the child was with the mother and the paramour, there were never any other injuries. The post-traumatic stress was something that came up in October of 2009, long after the child had been living with the grandparents.
Well, if the bruises didn't matter, if they were de minimis or whatever, then why did she deny that they were inflicted by the paramour, or say that she would never let the paramour be there again? It's strictly a question now of credibility. Whether you believe her on either one of those two things, that it wasn't the paramour in the first place, or that, which is not true, you just said so yourself, or I don't believe, I, the finder of fact, don't believe when she says she's not going to come back again.
So in the 2 years that they had this case ongoing and she was in therapy, there was never a point where they said, remove the paramour from the home and we will place the child back with you. And early on, that's all there were with the bruises, and they could have done that, but that was never something that they offered.
Wasn't she ordered to stay away from the paramour?
She was ordered to have no contact. What else is that supposed to mean, no contact? You can live with someone and have no contact?
No contact between him and the child.
No, between her and the paramour.
The mother was ordered to have no contact.
That was the other part of it, was her and the paramour, and she's saying, I can have contact with him. We no longer be living together. No longer will be an intimate relationship.
Which was not true.
But I will not allow him to have contact ever again with my child, if I could have my
Well, they're living in the same home. This is not
supposedly he
built for.
There was testimony that his parents and his sister said that he lived in their home with them for long periods of time.
Right, and I mean, she was ordered to stay away from the paramour. There was surveillance of the paramour's car, was at her apartment before, 5:30 in the morning, and late into the night she continued to have contact and relations with the paramour, despite the fact that she knew that this was the primary impediment to her reunification with the child.
I can't dispute that, but what I'm saying is that ultimately she said, this is it. I need to do this. And
yes, on the day of trial.
Well,
right?
Part of the trial.
Counsel, your time is up and you have some time left for rebuttal.
Okay.
Thank you very much.
Thank you.
Good morning, Your Honors. Larry Kambour for the Guardian Ad Litem Program on behalf of Karla Perkins for the Department of Children and Families. We're not splitting our time.
Is she letting you argue?
She's letting me argue today. Yes, Your Honor.
Kind of. In view of past events, she's forgive and forget, I guess.
Absolutely.
She's a wonderful person.
All water under the bridge. By your questions, Your Honors, clearly understand the issues. In the case that there was competent substantial evidence that this mother was given services, the primary of which was to understand the trauma that her child suffered while in her custody with the paramour, and by her actions demonstrated that she benefited not at all from those services. I'll point out that in addition to the tapes that Your Honors are aware of, that she expressed an interest in running from the jurisdiction where she'd given custody of the children so they could be together. And actually on the day of trial when she testified he is dangerous and she's never going to see him again, she asked for the no contact order to be lifted. That was at the same day. So clearly there was evidence for the court to determine that she lacked credibility when she promised that she wouldn't see him and that in fact...
What about Mr. Rockowitz's argument regarding the single parent TPR? Is there any merit to that? Under 38.811 sub 6 sub D, I think it is, for the protection of the child, that's certainly permissible, is it not?
Absolutely. And there's very little case law interpreting that subsection, Your Honor, the language protection of the child demanded. But the case law that is out there just says that the court needs to articulate what protection, what the problem is. And in this case, the court did precisely that. The court detailed that the child has suffered harm, physical harm, and PTSD as a result of whatever trauma she experienced while living, and that any mention of going back to their custody together was a trigger for further trauma. She had to go back into therapy. And then that trauma, that harm, coupled with the mother's failure to understand that her continuing relationship triggered this child's further harm, and her declaration that she'll flee the jurisdiction given the chance, and her continued, declarations to the court that she was going to break up with him, clearly, discredited by the tapes and her constant being seen with him going to take her to services but hanging out for 5 hours before and after the chauffeuring duties. All of this demonstrated, of course, she had no intention of severing this relationship and thereby had no understanding of the harm it was causing her child. So all of that together absolutely is competent and substantial evidence.
Certainly her actions prior to the trial didn't support her statement during the trial that she finally decided that she should sever the relationship, did it?
Absolutely. Absolutely. And after the trial, Your Honor, when she asked for the no contact order to be lifted. So for all of these reasons, unless the Court has other questions, we ask for any purpose.
Thank you very much. Counsel, would you like some time for rebuttal?
Just the point about the dangerousness, and they say in those cases, well, even if there's a case claim violation, even if it's irrespective of the provision of services, those findings as the basis for termination are not the grounds for termination in the case where you have a one parent and it's considered being dangerous as a standard. I just say that the mother throughout the visitation, throughout the therapy, was always described, no matter how negative or angry the child was with her, she was always appropriate and always caring for that child. But I just keep going back to the question about post-traumatic stress disorder may have occurred when with the grandparents even said, we do not feel it's our responsibility to help the child with her relationship with the parents, with the mother, that's up to the child to do. And there was such hostility in that regard. And I think other than, again, the bruises, if they could place early on that order of the paramour leaves the home and no contact between the child and the paramour, that wouldn't have gone to the termination.
Of course, in these cases, we would like to, but we're not trying the DCF, much less regarding that writer. We're trying the interests of the child.
Thank you very much to all of you. Have a good day.